Court calls case People versus Anika Skibb.
Mr. Riser, on behalf of the people.
However, on behalf of Ms. Skibb, who is approaching for him, Ms. Skibb, please introduce yourself to the court.
My name is Annika Skibb.
Yes, I mispronounce it every time.
Okay.
Thank you, Your Honor. Your Honor, today's the date and time set for pretrial and violation of bond. As to the, would the court prefer to address the bond violation first?
Hold on a second. Got it. Okay, go ahead.
Would the court prefer to address the bond violation first or the pretrial?
Bond violation.
Your Honor, at this time, Ms. Skibb is not going to contest the violation. She is going to admit the violation for drinking and testing positive on the silver link.
And Skibb, why?
Your Honor, I'm very ashamed because this mistake was absolutely not indicative of the work I've been putting in the last few months, regularly attending meetings, and I'm very involved in the AA community in this area. I did an assessment by First Step Referral Services and was advised to complete inpatient treatment, and this is not at all acceptable, but the idea of having to be away from my son and the stress of this case on me.
Here, the defendant admits he drank while on bond, a direct violation. In legal terms, this is significant because bond conditions are a promise to the court. Stay sober, stay compliant, and stay out of custody while your case is pending. His honesty may earn some credit, but the judge's job is to weigh his progress against public safety and reliability. Notice how he explains his stress and connection to his son. That human element often matters in these hearings, but it doesn't erase the violation itself. What the court is really deciding now is credibility. Can this defendant be trusted to follow the court's orders going forward? Or is this relapse proof that more supervision, even jail, is necessary?
I allowed it to get to me, and when I messed up, I panicked, but I am currently at Dawn Farm.
Do I have the violation?
And it is the 90-day program, correct? Yeah, so she's in the gold standard, the big one.
Well, I'm looking for my copy of the. How much were you drinking?
The day of the 20th, so the first day, I believe I had
The day of the 20th?
The day of the 20th is when I thought the report was sent from, Your Honor.
No, Ms. Skibb, have you seen the bond violation report?
I have not.
Have you had a chance to look at it? We discussed it, Judge, but we haven't.
Sorry, I was thinking about the 18th, Your Honor.
Yes,
On the 18th,
Yes.
you blew a .12.
I had 2 drinks. Was immediately after, I believe so. I believe 2 drinks, possibly 3. I don't remember exactly.
Then immediately after that, basically through that was at 10:33 when you blew those numbers. And then basically into the early morning of the 19th, you missed your testing.
Correct.
Are you indicating to me on the 18th, you had 2 drinks?
As the defendant discusses the timeline of his drinking, the judge meticulously checks his test results, 0.12 one day, 0.09 the next, and a staggering 0.267 by nightfall. That's not a small slip, yes, that's a full relapse. These numbers show not only consumption, but escalating use within 24 hours. Legally, this is more than a minor technical violation. It shows disregard for testing and the court's monitoring system. What's key here is that the judge doesn't rush to judgment. He's gathering the facts, ensuring every reading is documented, and verifying that the defendant understands what's being presented. This step is vital in due process. No punishment without full verified evidence on record.
No, Your Honor, I'm saying I don't remember how many. I believe it was 2 right before breathalyzing. I believe it was It was,
And then how many did you have after that?
again, I don't know, was a few drinks the next day as well.
What?
It was at least a few drinks the next day as well. I don't remember exactly how many, Your Honor. I'm sorry. I didn't measure.
Because then at 1, well, basically 2 o'clock that next day, PM, you blow a .09.
Correct, Your Honor. Like I said, I panicked and I was drinking for the next day, so.
You kept not retesting as it's required. And then by 9 o'clock that night, you blew a .267. Mr. Allen. And you say now you're in treatment?
Yes, I'm currently at Dawn Farm and I was in jail for 6 days.
Anything else you want to say?
Your Honor, Ms. Skip has been very honest and open with me about this and about her problems with her drinking. She is at, like I said, she is at Dawn Farm. From my understanding, I believe it is going to be effective, and correct me if I'm wrong, eager to get back on track. She is deeply regretful and remorseful of her mistakes. She's been honest with me the whole time, and I don't believe she's tried to hide this at any point. But we are asking that, Your Honor, that she be allowed to return to Dawn Farm rather than the custody of the county today.
And then what will I do with her?
I suppose see what happens at Dawn Farm after 90 days. She is inpatient. It is inpatient, Judge, if that makes sense.
Do I have it?
I'm
Do
sorry.
you have proof of that?
We don't have any. Do you have the written documentation here, right?
Here we reach the critical moment, the bond revocation. The defense attorney argues for leniency, asking that the defendant be allowed to return to rehab rather than jail. But the judge demands documentation, and when none is provided, his decision is clear. This illustrates a core courtroom principle. Proof outweighs promises. Even when a defendant is sincere, the judge must have concrete evidence, signed paperwork, official verification, or direct communication from the treatment facility. Without it, the court can't risk release. Bond revocation means the defendant is no longer trusted to remain out of custody. He'll return to jail pending further review. It's a sobering reminder that rehabilitation and recovery must be paired with transparency and accountability.
So I have documentation from the farm with me. I also signed a legal release of information to Mr. Bradell on Monday when I was admitted. I also
Right now, I don't have anything.
I have a peer with me that's from the farm that is also with me. If possible, we can call the farm. Whatever proof is needed, I will be able to get to you today. I didn't realize that I needed more than the legal release of information.
Well, somehow or another, that information has got to get to me, but this, based upon the violation that I see, defendant's bond is revoked. I'm going to remand her to the Washtenaw County Jail. I'll set it out 1 week during the sentencing and review that. But right now it's revoked. Defendant's remanded.
Understand.
Will be adjourned to March 19th, 2025, 9 a.m. or as your invite indicates. Set the defendant's bond at a $5,000 personal recognizance bond. I will order. Yes, sir.
I'm going to be in rehab. I got next 10 days. I'm going to be going into rehab for at least 30 days.
When are you going in?
Within the next 10 days. I'm in the process of getting hold of the number to the distribution center.
Okay. Where are you doing this rehab?
This is for Plymouth, Canton Township.
The court?
Yes.
Okay. Do you have paperwork indicating that?
On me, I do not. I just went to court yesterday for it. It's either 30 days in
So
jail.
here's what I'm going to do. You're going to need to get that paperwork to your attorneys here.
Okay.
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 So that they can show the court, but I'm going to leave it set for the 19th.
Within, to bring it up here to the courts, I feel like I'll have it within the next couple of days. You know what I'm saying? They're supposed to be sending me the number from Canton for the distribution center. And then I don't know exactly, okay. To you, right here. Okay, thank you. Yeah.
All other standard conditions, including no assaultive behavior or possession of any weapons. There should be no alcohol, recreational marijuana, or illegal drug use. You understand that, sir?
Yes, Your Honor.
I will also sign an order for community corrections regarding testing. At this point, it'd be 2 times per week, but if you're in treatment, then go with that.
We now move to another case in the same session, a man facing similar issues with substance use and compliance. Notice how the tone of the courtroom stays consistent. The judge demands structure, honesty, and proof. The defendant claims he's heading to rehab, but again, no paperwork. Courts operate on documentation, not verbal assurance. The judge's questions: when are you going in? Where? Do you have proof? Are not arbitrary. They're procedural safeguards ensuring defendants can't manipulate the system. The judge's skepticism here is justified. The defendant admits to recent drug use, yet says rehab is imminent. This creates a legal paradox. Intent to recover doesn't outweigh failure to comply. The court must protect the integrity of its orders.
If I were to give you a test today, you gonna come back clean?
Nope.
I didn't think so. What have you been using?
Okay. It's been 3 days or so, but it's still probably come back dirty.
What do you mean it's been 3
I haven't used anything in the past couple of days. But it's still, I don't think it'll come back clean, to answer your question.
Well, your bond on your other case in Plymouth, you're not supposed to be using.
Yeah, this is all right.
Why?
That's why I'm going into rehab.
Are you testing out there?
Not so just starting everything. I just went to court yesterday.
Let me just tell you. Okay. I'm gonna tell you right now, Mr. Allen.
Sentencing.
Young man,
Yes.
I'm gonna ask you this. I'm gonna ask you this once.
Yeah.
When was the last time you used?
It's been about 4 days. To be honest with you. Yeah, the honest answer is I can't give you an exact date, but it's been within 3 to 4 days, Your Honor. To be completely honest with the courts. That's one of the reasons I'm going into rehab. Because of my lack of control.
Where are you going to rehab?
I gotta get a hold of their 34th is sending me the number to the distribution center. I haven't gotten it yet. As soon as they get it to me, I'll know exactly then. And I can give the courts the information that I have at that point in time.
When did 34th order you to?
Oh, not 34th, 36th, Plymouth. Yesterday. I was just in court yesterday.
Okay. And they ordered you to rehab.
Yes. Is it 30 days in
What
jail?
judge?
Your Honor,
Goody?
I found the case, if I may.
Yes, go ahead, Mr.
It's before Judge Giroux in 35th. It does look like he appeared yesterday and pled. Their ROAs look a little bit different than ours, so it's a little bit difficult to understand. But it looks like he was sentenced yesterday at noon. It says optional jail term, but that's all I can really see. Optional term 30 days. But it looks like it that's all it says really about his sentence.
But it doesn't say anything about treatment.
It doesn't really tell me. Well, it says probation. it's pretty unclear. It says there's a bunch of entries with description. It says crime rights assessment. Oh, those are the fees. Optional jail term, probation, monetary transaction. He paid $125. Scheduled to report to jail 6/20/25. So that may be what he's referring to
Have a
when he
jail,
says.
you got a jail sentence?
If I may, Your Honor, my client seems to be the understanding that if he were to complete the inpatient rehab, he would not have to do that jail sentence, which I believe that might be why then his report date is in June 2025. If so, maybe that jail time will not actually be imposed if he does that rehab.
Right, because it says optional term.
Yes, Your Honor.
I can
Do
print
they
out.
know you, do they know you've been using?
No,
Yeah.
I think that's why I chose to go to rehab versus going to jail. I think rehab would be better for me than going to sitting in jail for 30 days versus going to the rehab. That's what I need. I think
Well, I
personally.
understand that, but that's not my issue right now. Did somebody bring you here?
Yes.
Okay, so, but my question really is, does the other court know that you've been using?
No. They have not dropped me yet.
Pardon?
They have not dropped me, no, sir, Your Honor.
Did you talk with anybody at the other court, their probation department, anybody?
Yes, I have.
Because I'm gonna be honest with you, sir, I think when you give me that 3 to 4 days, I think you've used more recently
No, sir.
just by the way that you're acting.
No, I've not used it at all. I've not. I promise, of course, I haven't used it. It's been at least 3, 4 days. Minimum. I'm a little nervous right now, to be honest with you.
All right. Well, here's what I'm gonna do. I'm actually gonna set the defendant's bond at a $15,000. I'll just do a 10% bond, but if he's got it, he can pay it. I'll set a special pretrial or at least review of his bond on March 12th, 2025 at 9 a.m. That's my sentencing docket. But that way he's not in a week. Ms. Payton, Ms. Farady, if you get information more specific for me from the other court as to what he's supposed to do, then I'll consider his release. But at this point, he's not leaving here.
Yes, Your Honor.
This courtroom session highlights one of the judge's most defining traits: balanced firmness. He recognizes addiction as a disease, but still enforces accountability. Both defendants showed self-awareness and remorse, yet both lack the documentation and consistency the court requires. By revoking bonds and demanding proof, the judge isn't punishing recovery, he's enforcing structure, the very thing recovery depends on. These hearings reveal a difficult truth. Compassion in court doesn't mean leniency without evidence. If you found this case as compelling as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more in-depth breakdowns of real courtroom moments with legal insight and analysis.